Welcome to QLTS School's video series on the SQE1 assessment. Today we will look at a sample multiple choice question on wills and probate.
A testator makes a will which contains the following clause. My property, 87 Main Street, Anytown, I give to my son. However, the testator has never owned a property with that address. He did, however, own a property in Anytown with an address of 81 Main Street. The man dies. The executors obtain probate and declare to the son that the gift is invalid and the property therefore falls into the residue of the estate at the same time the grant is received. About a year after the grant of probate, the son comes to see you as he wants to contest the validity of the will. Can the court rectify the will? A. The court can rectify a will to remove the effect of a mistake, which is the result of a clerical error, but the son's claim is out of time. B. The court can rectify the will because it had a clerical error. C. The court can rectify the will because there was a failure to understand the intention of the testator. D. The court cannot rectify such a substantial mistake in the will because it is beyond its powers of rectification. E. The court cannot correct such mistakes by rectification. The correct answer is A. The court can rectify a will to remove the effect of a mistake, which is the result of a clerical error, but the son's claim is out of time. There is a crossover between the principles of interpretation and rectification. In many cases, the same result may be achieved by more than one route. For example, a simple mistake may be remedied either by interpretation or by rectification. Section 20 of the Administration of Justice Act 1982 allows the court to order that a will should be rectified so as to carry out the testator's intentions if it is satisfied that the will fails to carry out the testator's intentions as a result of clerical error or a failure to understand the testator's instructions. In the case of Marley and Rawlings, 2014, a husband and wife accidentally signed the will of the other. The case ended up in the Supreme Court, where rectification was allowed. However, there is also a time constraint as to applications for rectification, like applications under the IPFDA, which must be made within 6 months from the date of the grant of probate. Any claim brought after this period will require the permission of the court, which will take into account the reasons for the delay in seeking rectification, and in particular whether any prejudice has been caused by the delay and whether the proceedings were pursued in an efficient manner. Since the client approached you about a year after the grant of probate, the avenue of rectification is not available without the court's permission. The fact pattern does not suggest there were any unique circumstances that the court should have regard to. It follows that option A is the best answer.